Thank all of y'all for coming, and anybody who isn't a member, please consider joining Leaders with Vision. We're a nonpartisan, nonprofit organization without borders. We will discuss any issue from all points of view that the citizens are interested in. Having said that, I'm going to have to ask, sir, you're going to have to tell me the time. And we have 58 minutes total, okay? And subsets that the speakers have 7.5 minutes each, okay? Or 7 minutes. Let's do 7 minutes.
It's a long time.
7 minutes. You can always give up part of the time, okay? Anybody has a question, please write it out while it's fresh on your mind and send it up. Just raise your hand and Dean and John will pick it up. All right, with that, allow me to say, are you guys turning on the other thing? Are you ready? You ready? Okay. Welcome to Leaders with Vision. This is our kickoff of the August session. We always go dark during the summer, respecting that everybody's tired of politics and also wants family vacations. I'm Gene Armstrong, and I'm president of the league, the Leaders with Vision. Did it again. Can you cut that? Anyway, that's raging years a little difficult. First of all, for those of you that this is a showdown over gun control, let me assure you, I'm a certified concealed permit holder. But that does not make me James Bond, nor does it give me a license to kill. And we felt that this subject, which is cropped up all over the country, from Connecticut to Florida, we need to find out what the law really says, what its provisions are, and how we should conduct ourselves should we have a weapon. Having said that, each of you received a copy of our outstanding panel, okay? And for the purposes of the discussion of the law, why don't we start with Shenequa Gray. Shenequa, if you would tell us all about the differences and what Louisiana law is all about on Stand Your Ground.
Good afternoon, everyone. Good afternoon, everyone. Thank you for having me here. This is certainly a timely topic, and it's one that lots of people are interested in. And it's very important to me to try to certainly educate people on the provisions of this law. It's something that I've been doing for over a year now, doing research on this particular law. I've done I've done some research on it. And so I'm happy to have an opportunity to talk about this with you all today, and I look forward to your questions at the end. But I think one of the key problems with the Stand Your Ground law is that people don't really understand its provision. So I'm glad that you all are here and that you have some interest in that particular issue. So first and foremost, I think most people know, and if you don't know, the basic provision that we have when we're talking about Stand Your Ground law, what it pretty much does is just expands what we have already known and the law to provide in one's home, which is that it removes any right to retreat prior to the use of deadly force. What Stand Your Ground law does, it expands that right to places outside of the home, and it removes any duty that a person has to retreat prior to the use of force. But let's talk more specific about what those provisions provide, because we know that Stand Your Ground law is applicable in more than 30 states in various forms. So I would just like to kind of generally speak to you about what the general provisions are and what are some of those additional provisions that are prevalent in some of the more controversial states. So generally speaking, a Stand Your Ground law does remove the right to retreat prior to the use of deadly force if certain requirements are there. And we know that retreat is you would not have to try to run away, hide, or in any way try to remove yourself from the situation prior to the use of force or deadly force if 3 requirements are present. One of those is that you are where you have a right to be. Okay, so you might be in a park or in a backyard or a common area of a neighborhood subdivision or whatever the case may be. Also, you're not involved in any unlawful activity. So that would usually be you might be doing something criminal like selling drugs or involved in stalking or some altercation. So you're where you have a right to be, you're not involved in unlawful activity, and there exists a legitimate right to use force to defend yourself. Most laws in most states are pretty consistent with those situations where there's a legitimate use of a right to use self-defense, specifically deadly force, and that is if it is necessary to prevent your own death, some forcible offense against your person, or serious bodily injury. So those three requirements must be present, and I think that's first and foremost. People need to understand that, you know, those provisions are necessary. So it's not some sort of unreasonable license to kill. It is a legitimate need, a legitimate opportunity to use force to protect yourself. You're where you have a right to be. You're not involved in unlawful activity. And in those circumstances, you can use the force, including deadly force, to prevent that offense against yourself. Now, that's pretty much what Louisiana has. That's what most states have. That language is almost verbatim across the 30-plus states that currently have stand your ground laws. But what are some of the more controversial provisions that some of the states have, including Florida? And there are about 3 or 4 provisions. Florida has, for example, this criminal immunity provision. And basically the criminal immunity, and I'll just read briefly what it says. It says that a person who uses force as permitted in that stand your ground statute is justified in using such force and is immune from criminal prosecution and civil action for the use of such force. And it goes on to say, which is another very controversial provision, it says that, but the agency may not arrest the person for using force unless it determines that there is probable cause that the force they used was unlawful. So basically what that means is that when law enforcement arrives on scene, if it appears as though there has been a reasonable use of force, a reasonable use of deadly force even, law enforcement are unable, the law specifically says that law enforcement cannot arrest that individual unless after an investigation they determine that probable cause exists that the force used was unreasonable, okay, or that it was unlawful. This is the reason why we saw in states such as Florida that we have defendants who are not initially arrested because they are prevented from doing so. Basically, law enforcement is prevented from doing so until after an investigation concludes that there is probable cause that the force used was unreasonable. Now, the problems with that, and I'll also say that we have this immunity provision, and I only have a couple minutes left. So we have this immunity provision, and the immunity provision basically also gives that person immunity from prosecution. Now, usually that is done in an immunity hearing where the judge determines that that person is immune from criminal prosecution. Now, I want to just get really briefly, very quickly rather, to the main issues, I guess, as to why we're here, which is to talk about, you know, recommendations and the potential for abuse. When you have that criminal immunity provision, which is a determination made by the judge, when you have a person who's prevented from being arrested from law enforcement, what you ultimately have is that you have the potential for abuse by law enforcement or even the state, because it gives that potential for discriminatory application. When you have the police officer being able to make those decisions before that person is even arrested, you also have another opportunity where the judge can kick a case out through the immunity hearing and determine that that person is immune from prosecution. You ultimately prevent these cases from ever even making it to a jury to make a determination as to whether the amount of force used was reasonable. And not only does it have that potential for discriminatory applications, I mean, there have been studies done on stand your ground laws, which we know are pretty new, they only came since 2005, that have shown that there have been a disparate application of stand your ground statutes, but also they lend themselves somewhat to unnecessary deaths. Because the statute is so skewed in favor of the defense, people are resorting to the use of deadly force more often now, as well as the law is designed to sort of help the defense, so to speak, because you have that situation where the person has these numerous opportunities to overcome the offense, whether it's arrest in the beginning, criminal immunity determination by the police, and also the state has burden of proof. at the trial to conclude that the person was not, it was not a valid use of force. So hopefully I can elaborate on some of these issues during the question and answer period, and I thank you.
Thank you. And our next presenter is our brand new police chief, Dabadie. From a law enforcement point of view, you can tell us all about it.
Yes. Well, good afternoon, and just want to thank y'all for inviting me here today to speak with you on this topic. As a previous presenter said, this is a very controversial topic right now, and there's several lawyers up here who will talk to you from the legal side of it. I'm going to try to talk to you from the law enforcement side of it. From the law enforcement side, basically, our job is not going to change, whether we have that law or not. Our job is to go out to the scene, investigate whatever has happened. We collect that evidence, we gather the evidence, we collect DNA, we take statements, we do everything on the law enforcement side of it, and then we present that package to either a prosecutor or the district attorney's office for trial or for their prosecution. So from our standpoint, that's our role to that point. Now, what the Baton Rouge Police Department suggests, I guess would be the best way to say that, is the community is our first line of defense. We would much rather you be a good witness than be involved in this type of incident. And what I mean by that is, let's say that you have someone that's breaking in your house. You know, we as law enforcement would much rather you, A, grab your phone, call 911, get us en route. We are the people that are trained to handle these situations. We have the technology, we have the equipment, we have everything that we need to handle that situation. You, or citizens on that part, may not have that. And I'll get into that a little bit more in just a second. I know I'm on a time schedule. But we would much rather you be a very good witness for us. We don't want you to encounter the bad guys. That's what we get paid for. That's what you pay us to do, is to take care of the bad guys when they come to your house. When the wolf is knocking at the door, it's our job to come take care of the wolf, not yours. So we would much rather you become a good witness. Get on that cell phone or your regular phone, call us, get us en route. Have a plan. Know what you're going to do when that happens, whether that's barricade yourself in your bedroom, barricade yourself in a room or a bathroom, get on that phone, take care of your family. If you have kids, have a plan of what you would do in that situation. Now, like I said before, law enforcement goes through hundreds and hundreds and hundreds of hours of training in dealing with the criminal element. And to be quite honest with you, that's not enough. We need more and more training. As technology goes and as the legal situation goes, every year there are new things come out. We need more and more training. So let us handle the criminals. You know, we have things such as tasers, we have mace, we have ground fighting techniques, we have verbal judo. We deal with our mental health agencies to teach us how to deal with mental health people. And if you've been looking in the paper, we're having an increasing issues with mental health patients. And that's a whole other issue, and I don't have near enough time to talk about that. But anyway, we're trained to deal with that. So let us deal with that. Let the law enforcement professionals deal with that. Don't put yourself in a bad situation to become a victim, or worse than that, a suspect in a crime. That's what we don't want. You know, part of our responsibility as law enforcement is to teach the community. We hold numerous self-defense classes throughout the year, especially when we come around the Christmas time and so forth. When we get into those self-defense classes, it's inevitable. At some point during that class, somebody's going to raise their hand and they're going to say, I want to know how I can go get me a gun and carry it with me and use it to defend myself. Well, the first thing we tell them is, don't go buy a gun. Because before you buy that gun, we need to talk about a few things. All right? When you buy a gun, you take the responsibility of that gun. You know, this isn't the movies. This isn't when the movie's over, everything's going to be fine, everybody goes back to their normal everyday job. If you have to use a weapon, especially a gun, that weapon has a projectile in it. When you pull that trigger, that projectile comes out. You are responsible for wherever that projectile goes. Whether you intended it to go somewhere or you intended it not to go somewhere, the problem is you're responsible for that. Our officers go through hours and hours and thousands of rounds of training to learn when to shoot and when not to shoot. Target identification. What's behind the target that you're shooting at, just in case you miss. Those things are very, very important, and it takes a lot of training to get our officers on that level. You as a civilian would not get any of that training. So, well, no, she's quick with them fingers. But our point is, there's a lot of responsibility that comes with a gun. And if you're not willing to accept that responsibility, then our suggestion to you is that don't get a gun. Get a cell phone that you can keep by your bed. Get a phone that you can keep with you. Dial 911 and get us there. Let us handle the bad guys. That's what we get paid to do. It's much better for you to become a witness as opposed to a victim or a suspect. That's our message to the community. That's what we want you to do. And I think I'm at my 1 minute mark. No, I'm good? Well, I'm going to give Hillar that extra minute. Can I give Hillar that?
Give it, Sheriff.
Well, thank you for coming. I'll be more than happy to answer any questions that you may have for me during the question and answer period.
Thank you, Chief.
Thank you.
Two things before I bring Hillar up. Number one, to add to what the Chief was saying about keeping a phone on your bedside. The other thing is keep your car keys. You can always set off the alarm in your car, and that can cause confusion for anyone that's on home invasion. The other thing is, someone asked, how many people in this room currently have a legitimate concealed weapon permit? Raise your hands. Okay. I'm glad to see that you're here, and I'm also glad to see the numbers, okay, that they are. Anyway, our next presenter needs no big introduction. Our district attorney, Hillar Moore.
Thanks, Rob. You can tell the sheriff's not here. The sheriff heard that we only had 7 minutes to talk, and he can't do anything in 7 minutes, so he declined to come today. Make sure you let him know that I said that. Maybe unlike the other speakers, I do not see a big issue with stand your ground. This is, particularly in Baton Rouge, but this really starts way in the past, in the 1600s in England, with the castle doctrine, and it's based on the poorest man may in his cottage bid defiance to all the forces of the crown. It may be frail, its roof may shake, the wind may blow through it, the storms may enter, the rain may enter, but the King of England cannot. So every man's home is their castle, and you have the right to defend yourself and your home. And that's where this law has eventually come from. In Louisiana, we have two statutes that deal with this. It's 1419, which is use of force of violence against another, and that's for all instances that are not homicide. Then we have the justifiable homicide statute in 1420. Both of those clearly state since 2006 that you may stand your ground and don't need to retreat. Now, I've looked through the past many years of Baton Rouge with the 50 to 60 assistant DAs that we had, and I asked them, can you tell me how many cases that you've dealt with that may somehow involve stand your ground? And from that short notice, I had a total of 6, and we've had 80 or so murders per year, and so if you take 6 cases, maybe over 10 years, very few. In reviewing those 6 that I have, the majority of these 6 are really just self-defense cases and not stand your ground cases. And in these cases that I've found, half involved white defendants, suspects, half involved black. And what seemed to be more evident to me in these stand your ground types of cases were they more family related or the folks knew each other. So that's where I see most of this that's going. There's only really one reported case from this 2006 legislation that came out of the Second Circuit, and that's the case where a husband remarried, he's in his home legally with his new wife, and the ex-wife comes in the home, she's not allowed, so she's there unlawfully, the man is there lawfully, and the two wives start fighting each other, the husband does not retreat, doesn't have to. The husband gets his gun. There are no other guns that are involved with the females to my recollection, and the husband takes the gun and he shoots the ex-wife. So he gets indicted. He's claiming self-defense, defense of others. He's claiming the new legislation, stand your ground, and this is what the court said in that case. It says, yeah, we do have that stand your ground law, however, the presumption of reasonableness is not a license to kill. So although we do have the stand your ground law, you don't have to retreat, although sometimes it may be in your best interest to retreat. The court and the police department first, they're going to look to see whether your actions are reasonable or not. If they're not reasonable, I can guarantee you that they're going to arrest you. Then from that stage on, and that's based on probable cause, following an arrest, that case will then eventually be presented to the district attorney, for more than likely for a presentation to a grand jury, and then you have 9 to 12 citizens of the community going to determine whether your actions are reasonable or not in light of this statute. 2 of the 6 cases that I saw that I've mentioned to you, the grand jury pre-committed. That is, they couldn't make a decision whether the actor, the shooter, was right or wrong, and there just wasn't enough evidence one way or another to tell. So those cases could possibly remain active if future developments come about. One of the other 6 was a person who claimed self-defense and tried to use this statute, but he turned out to be the aggressor, and he was convicted of second-degree murder. So again, although this law is here, we are completely different than Florida. The police do not have handcuffs on them where they can't arrest someone. Again, their arrest is based on probable cause. And so this is the law. It may be controversial. I think sometimes it gets a bad rap because it's really self-defense and not traditional stand your ground or the new stand your ground law. So although we see these cases, they're very infrequent and they're handled on a case-by-case basis. And you have to be reminded as a homeowner that your actions really have to be reasonable. You can't be the drug dealer in the home. The law has a specific exception for that. But if you're just a true homeowner and you're defending your home or others in your home and your actions are reasonable, then that's why that law is here. It's here to protect you as legitimate, lawful homeowners defending your home and your property and your children. Thank you.
Somebody picked up my cheat sheet.
That's all.
Listen to it. Anyway, our next person is Michael. Where's my cheat sheet? Michael Mitchell, and he is the chief of the Public Defender's Office, which handles cases of this nature for people who can't afford it. Michael? Most of y'all don't get to meet him. Thank you.
I'm going to give you, I think, what you might consider a schizophrenic or contradictory view of our stand your ground law in this state. I've spent most of my career as an attorney practicing criminal defense law. Most of that representing indigents in the criminal justice system. And as a result of that, I have represented quite a few people who have been accused of committing homicides, some of whom have done it in self-defense, in defense of either themselves or others. And while I've never actually used in court the stand your ground provision of the law, as it's fairly new, I've used the self-defense provision quite a bit. Self-defense is raised in this state when the client can show that he or she reasonably believed he was in imminent danger of losing his life or protecting the life of another. The stand your ground provision was added because previously to that, in most of the country, you had a right to self-defense, but you had to show that you had an opportunity or didn't have an opportunity to retreat before you use deadly force to defend yourself. Now, you don't have to show at all that you had an opportunity to retreat. You have no duty to retreat. And in fact, when you're in your home, called the castle doctrine, you definitely have no duty to retreat. For example, if there's a burglar who's trying to get into your home, you have a right to protect your home in any way that you deem necessary, as long as it's reasonable and the law indicates that it is presumed to be reasonable. If you are where you're supposed to be in your home and the person trying to get into your home is attempting to get in unlawfully. And the jury, if you are charged with a homicide, cannot consider that you had an opportunity to retreat, either in your home or standing your ground in the parking lot. The stand your ground portion of our justifiable homicide serves the purpose of enhancing our right to use deadly force in defense of ourselves or others by removing any question of whether you have a duty to retreat before you can use such force. The former duty to retreat basically meant that a person who is under an imminent threat of personal harm must retreat from the threat as much as possible before responding in self-defense. We have removed the duty altogether. Now, from a defense attorney's perspective, stand your ground, it can't get any better if you're representing someone whose defense is either self-defense and he's standing his ground. It simply gets no better than that. Except the one way it really gets really good is when the police department comes out and investigates a homicide and the lead detective makes a decision at that point that the homicide was justified, that my client was in a position where he had no duty to retreat and he was standing his ground. It doesn't get better than when you're going to trial if he's eventually indicted or charged with murder, to have the investigating officer on the witness stand saying that when I got there, I believed your client and I believed he was standing his ground and I believed he was justified in committing this homicide. It does not get any better than that. As indicated previously, the only way that you can't use the stand your ground provision is if you are in fact engaged in some illegal activity yourself, specifically if you are in position of dealing drugs, for example. There's a case in Lafayette recently where there were two intruders who broke into this guy's house. A gunfight ensued. He's been arrested because after the police searched the home, they found drugs in the home. Now, he may not eventually be prosecuted for murder, but he's certainly going to be prosecuted for the drug charges. Also in a recent case in Jennings, this is the way you really should use the stand your ground rule. There was a person who burglarized, in the process of burglarizing a home, and this happened earlier this week. In the process of burglarizing the home, the homeowner woke up, got his gun, and went into the living room, or wherever it was, and held the burglar at gunpoint until the police came. He didn't shoot him. You don't have to shoot somebody. And in fact, the police found that the burglar had knives on him. So it could have been a case where had the homeowner shot the burglar, he would have been probably not prosecuted because of the castle doctrine and the fact that this burglar was in his home in the process of gathering whatever items it was that he intended to steal. As Mr. Moore indicated, we have not had very many stand your ground cases. Now, I had one in particular that could have been a stand your ground case, but it did involve a domestic situation where my client was in the process of getting a divorce. She shot her husband. It had been an abusive situation, and we decided to settle the case, and I'll be happy to talk about that and anything else if you have any questions. Thank you.
Thank you. And now, if you have questions written out, please raise your hand, and Dean or John will come by and pick them up. First, we'll have a question from, let's see, Scott Wilfong wants to know, why do some say that stand your ground was used in the Zimmerman defense? It was never mentioned in the trial. Scott, I think I can answer that. It wasn't used. Anybody want to go ahead? Up here.
Stand your ground statute was applicable in the Zimmerman trial, and technically it was used and the jury was instructed on it. But the reason you didn't hear about it at the actual trial was because it really did not change. It really had nothing to do with the case. For instance, as we've all said, stand your ground just removes any duty to retreat. There was no allegation in that case that he even had a duty to retreat. So let's say, for instance, he had been out in his front yard and you had the prosecution claiming, well, he could have clearly gone into his garage. Then they would have been talking about the fact, well, he didn't have to retreat because he was under the stand your ground statute. But based on the factual scenario involved in that case, whether or not he could have retreated was not an issue because there wasn't really anywhere to retreat anyway, but it was applicable to the case. The jury was instructed on it, and it may have even come into play had there been a question of whether he was engaged in unlawful activity. There were people saying, well, wasn't he stalking, and all that type of thing. But if any of those had been an issue, you would have heard them talking about it more. But since none of those were applicable, they didn't talk about it, so to speak, but it was applicable in that case.
Hello? You gotta stand up here.
Yeah, I don't know all of the facts of that case, but I would agree that stand your ground, in my opinion, had nothing to do with that case, and it was a classic case of just whether you believe self-defense or not. Whether they read that as a jury instruction, I don't know. I think that maybe this stand your ground got some wheels because of that, because it was mentioned, but to me it had nothing whatsoever to do with that case.
I think one of the issues in the Zimmerman case, and this was a question for the jury, stand your ground was not used as a defense by the defense. However, in the jury instructions, the judge gave an instruction on stand your ground. So what was the jury to do with that? If she gives an instruction on stand your ground, then it implies that the stand your ground defense is a part of the case. And I think in some of the interviews, a juror or two indicated that they thought George Zimmerman was standing his ground. And I think the prosecution failed in that case in making it clear that stand your ground was not used. They should have attempted to prevent that instruction from coming in. And had they done so, the result may have been different.
A rebuttal?
No, sorry, not rebuttal, just an additional.
Okay, but quickly, because we've got a bunch of questions.
Okay, I just wanted to briefly add to that, though. Florida does have that immunity provision, and it also has the prevention from law enforcement from being able to arrest unless probable cause exists that the person was not it was not a lawful use of force. So that probably is the reason why George Zimmerman was not initially arrested. So it also came into play prior to even any arrest or prosecution of the case.
Okay. Well, Chief, this one's going to be coming directly to you. And I'm going to expand it just a little bit. We talked about the use of stand your ground. We know we have troubled areas in 70805, and I believe the other one's 70802, is that correct?
Pick one.
But what I'm saying is homeowners in those areas frequently tell me they are frightened by bullets whizzing past their house, embedding it in their living room or their bedroom. Could they not use stand your ground? That's part of it. And the second part of it is, what is the average police response time to a burglary in progress?
Okay, let me, can I have the question again?
Well,
I know there's two parts.
Yeah, there's two parts. The first part, I said I expanded it.
Okay.
Can they use should they be using stand your ground to protect themselves instead of it
In their
becoming a
own
war
home?
zone out there? In their home.
In their own home? Do I have the person asking that question? I mean, we don't want to, I don't want to stand up here and tell you that, I guess I'm understanding the question as being that I'm in my home, I'm in one of these troubled areas, but a bullet comes into my house. Am I able to stand my ground at that point and retaliate back? Is that the question?
Yes.
I wouldn't do that. No. I wouldn't recommend that at all. I mean, what happens is you turn a very volatile situation into even more volatile by you sending rounds back. We don't, you know, as I was talking about earlier, projectiles and technology these days, bullets can go a long way. They can go through a lot of things before they finally come to a rest. And if someone shoots from one area and then it comes into the house, I mean, we don't want to get into a point where we're telling you to retaliate back and you may not even know what you're shooting back at. Just slinging lead or shooting bullets out of your house in protection of a bullet that's already entered, we wouldn't suggest that at all.
Okay. And the other one was, what's your response time?
Burglary response time, you have to understand that our call system goes on a priority system. You call and say that I have someone breaking in my house, that's a priority call and it goes to the top of the list. I would say anywhere from 3 to 5 minutes would be our response time.
Okay. Thank you.
With regard to like 70805 and house being shot, standing ground really wouldn't apply kind of in those positions. Back in the day, olden days, when someone wanted to fight you or they had trouble, they'd do it face to face, and they'd either punch you or if they wanted to shoot you, they'd shoot you right here in person. Nowadays, we deal more with cowards, and the cowards we have automatic weapons, and they're driving by and they just blast 16 to 20 rounds. So you're really not confronting the person, they don't know, and so they're blasting out your house. So it'd be really hard for you to just run out, I guess, and then maybe shoot at the cars that leaves, because then you may hit some other folks. So generally, standing ground on those cases that we have are not going to apply. But if someone's coming in your house and they're shooting, you absolutely have the right to defend yourself, your property, and your children. And if it's reasonable, we can take that action.
Thank you. Another question. This seems to come down to whether the person who uses force believes they are threatened. How can we expect investigators or juries to read someone's mind, and how can a prosecutor ever prove beyond a reasonable doubt that they acted appropriately?
That is an issue because everything is intent and state of mind. And so we cannot go into someone's head and look what was in their head at that time. So you have to rely on witnesses and their actions. You have to rely on sometimes some scientific evidence that you have, but it does make it very difficult, and that is the dilemma that our job presents us, is trying to get into someone's head. But it's always the attendant circumstances that you look at, and that's generally what carries the day. As to jurors generally, in our opinion, I think Mike would agree, generally get to the right decision for the right reason, and they're very good. They got some really good BS meters, like psychologists and counselors have. They generally can cut to the chase and tell who's lying or not by a lot of body action, but generally it's really just the attendant circumstances.
Okay. Question from Robert Phillips. I would like to know if there's been an increase, a marked increase in people getting concealed weapon permits since the Zimmerman case. Question number one. And question two, I also noted that when asked who had weapons in the room, no Americans of African descent raised their hands. Who wants to take the question? It's a two-parter. Chief?
Well, from what I read in the newspaper, there have been an increase in concealed gun permits, and I think they're really far behind right now. I know there's a lot of people that are private citizens that have opened up their own companies that are certified. So there's a larger number of concealed carry permits, but the downside to a concealed carry permit is that, okay, now you have received training, and they know what your training is. They keep that manual in the booklet in the trainer. You sign in, you sign out. They tell you about what the law is with stand your ground, and they talk about reasonableness. So now you have been educated on the job, and you better be reasonable. They tell you about drinking and using drugs and using a weapon at that time. So I think it really shifts the burden, so it's maybe not a protection.
Thank you. How should a threatened person announce to an aggressor that they are threatened and may use deadly force?
Well, I think for the most part, you need to be verbal. You need to be loud, and you need to be clear in anything that you say. And if you are threatened and if you are scared, you need to let that person know that. You need to let that person know that, and a lot of it's going to dictate the situation and what's going on. I understand that you may not have a lot of time to say something or to express what you're getting ready to do. But a warning would be very helpful. Just a verbal, hey, stop, I have a gun, I'm going to shoot, I'm going to do whatever it is that you may be doing, but I think a warning would be appropriate. A verbal, loud warning.
Thank you. Does Louisiana protect guard dogs from prosecution and execution?
Guard dogs?
Guard dogs? You have a dog in your backyard, it's a German Shepherd or Rottweiler, and somebody is trying to break in your house? One of you?
I have never prosecuted a dog yet, but
The owner of the dog.
owner responsibility. There's a city ordinance that's called owner responsibility, but I don't know that I've ever had one that have used that. So I mean, there can be a possible violation.
Let's say that the dog is in your house.
Okay.
Sticks their leg through the window.
Oh,
And the dog bites it.
hopefully no one's gonna arrest you, and surely won't be prosecuted for that. Would someone try to sue you civilly? Who knows? There's a lot of lawyers, but no, you would absolutely not be prosecuted by that.
She's asking about
Could you,
from the bad guy shooting the dog, I think is what she.
from a bad guy shooting your dog, could you shoot someone in defense of a dog? If you're defending your property, I mean, that's your property.
Inside your house. Inside your house. Inside your house. Okay. Asking for clarity, did Mr. Moore say a concealed weapon license liability for the permit holder, absent any other illegal actions? I'll let you look at it, Mr. Moore.
I'm missing can you,
I thought that I heard you say that if you get a permit, that it actually increased your liability from the standpoint of,
I think you just, in my opinion, as a lawyer, it may be more civilly than criminally. Criminally, you're going to be protected, criminal charges be protected by the statute, but I think your knowledge of the laws and you've been taught about the different provisions I think you're heightened, in that regard. Like, you can't say, well, I didn't really know all the statutes, never read statutes before. I'm just a regular person. Someone has a concealed carry, kind of had that training about, what the statutes are and you've signed off on. That's my only comment. It just goes to your knowledge. Yeah.
Don't sit down. Does a threatening person have to be inside my home for me to use deadly force?
No. There's two statutes. One is the use of force or violence. The other is justifiable homicide. So it depends on what that person is doing. If the person is trying to attack you and kill you, and you use deadly force, and that is what is reasonable under the circumstances, you could be inside your house or out. I mean, it happens both ways.
Thank you. Hold on a second. Are there any instances where protecting property are grounds for using deadly force? Chief?
I think there would be an instance where, in conjunction with protecting the property, and if you mean your home, the castle doctrine allows you to use deadly force if somebody is attempting to unlawfully enter your home. That's a protection of your property. If you are in the case, like the case in Texas, where somebody next door was robbing his neighbor, and these two guys are going down the street with big screen television sets, and he's on 911 saying, I'm gonna shoot them. They're burglarizing my neighbor's house. I'm gonna shoot them. And he shoots them. Well, in Texas, that works. Here in Louisiana, I hope it doesn't. I don't think it would.
I'll just make a comment.
I think a key point that we need to understand and realize is the word reasonableness. And, when you start asking and talking about property and protecting the property, it makes a big difference on whether someone went under your carport and is riding off on your bicycle. Would me shooting that person be reasonable to the crime that he committed? Probably not. But if they're inside the house and they're damaging your property or something a lot more violent, then it may. So it just kind of depends. So you got to use that reasonableness word in there.
Reasonableness or common sense? Okay. Mr. Mitchell, can you explain and compare the domestic violence of self-defense of a client to that of Melissa Alexandra in Florida? Not everybody may know Melissa Alexander's case, so if you could just very briefly, two more questions.
All right, that's what I was going to get into. I prepared a 15-minute talk, and I tried to condense it down to 7. The case that I had was a domestic violence type case. My client had been battered by her husband for 20 years or more, and they finally separated. She was in business. She had a home medical transportation business. She had one vehicle. He came to her home, took the vehicle because he knew that that's the way she made her living, and he just wasn't going to have it. She follows him. He stops, gets out of his car, and he's coming back to her window of her car with his fist balled up, and she shoots him. Well, to me, that's a stand your ground case. And we, as I said, we didn't take the chance. She was charged with second-degree murder. She spent 2 years in jail before we finally resolved the case. She is now out, and all is well. But that to me was a self-defense, stand your ground type domestic case. Much like Melissa Alexander, who in Florida was separated from her husband, went over to the house when she thought he was not there. He came home. He admits that he was arguing with her and would have beaten her had he had the opportunity. She ran into the garage where she kept a gun, got the gun, came out, confronted him because she says that was the only way out, and she shot the gun in the air through the ceiling. And in Florida, she received 20 years for that offense. In Florida, and she was prosecuted by the lead prosecutor on the Zimmerman case. She happened to be black. It seems that, and that's one of the problems that I have with the stand your ground law, is that it doesn't appear that it's always applied equally along racial lines. I've looked at some of the stats in Florida, and in Florida, it appears that if there is white on white stand your ground cases, then it's about even. If it's black on black, it's about even. But if it's white on black, then it's justified more times than not. And if it's black on white, the person who did the shooting, who's alleged stand your ground, is convicted. And unlike the Florida law, our stand your ground is really just a duty. You no longer have a duty to retreat. So it's not like Florida's. But I think stand your ground gives people who might otherwise not use their weapons or who are prone to stereotypes, typing people, use their weapon more rapidly simply because they think you have a right to stand your ground under any circumstances.
Just want to briefly add something to this as well as the last question regarding the right to use deadly force to protect property. That just doesn't exist in the law. When we're talking about a person being, whether they're inside of their home or inside of their car under the carjacking statute, all of those laws are not designed to protect the home. They are designed to protect the people inside of the home. And as they indicated, if you're driving down the street and you see them going out the window down the street with your flat panel television, stand your ground doesn't apply because it specifically says to prevent death, grave bodily harm, or forcible injury against your person. All those statutes are designed to protect the people and not the property. And secondly, on this Marissa Alexander case, I did a lot of research in that case because there was so much outrage over the fact that she had gotten 20 years for what seemed like should have been an appropriate application of the stand your ground law. But after looking at all the court proceedings, listening to transcripts, and even listening to the 911 call that was made, what was the deciding factor in that case is that her and her husband were involved in an argument. She went out into the garage, she got a weapon, and the bullet was fired into the wall in the direction of her husband and her 2 children who were standing right beside her husband. And at the end of the day, the stand your ground only allows you to use deadly force to protect your life or the lives of someone else, or to protect you from serious bodily injury or forcible offense. And the judge concluded that when she was out in the garage, that was a safe haven. She could have just driven the car off. So to come back inside, if you were ever to do that, if you go outside and get your car and come back inside, or if you do go around the corner or go and buy a gun, then you can't claim that it was necessary to protect your life at that particular time. And that's the reason why stand your ground didn't apply in that particular case. And because of their dangerous weapon acceleration on their statute, that was the reason why she got the 20 years.
Thank you. All right, we're going to shorten this time up. There's one, and if you can answer this very quickly. Has East Baton Rouge Parish had any cases of prosecution related to defense of others outside of the home? Will that person be prosecuted if they are preventing a crime?
Knowledge, we've had no one prosecuted that's legitimately defended a third party. You saw the paper today, the grand jury yesterday returned no true bills against the person who shot and killed another person. It was a self-defense claim that he was protecting the life of not only himself but another, and grand jury returned a no true bill.
Thank you. Have we got time for 2 questions, ma'am? Okay. if I happen to be in another's private property, uninvited, and I'm threatened by another who is not properly, not the property owner, does stand your ground apply if I use deadly force?
Yes.
The answer is yes?
Yes.
Thank you. And we are going to close with a question to the chief. Chief, is it possible to have more police visibility in troubled neighborhoods? I see many police cars parked at businesses, business places, and none driving through our neighborhoods.
That is that's a request that we get a lot. Unfortunately, I only have so many people to put out. We have increased patrols in a lot of our areas. What a lot of people have to understand is that a lot of times I have officers who are working extra duty at those businesses. That's why those cars may be there.
Yeah, get away from their mic.
I'm away from their mics, I'm sorry. I have officers who are either working extra duty or they're in court or they're out. We encourage them, we ask them, we make them, we assign them to these neighborhoods where there are problems, where we're having issues on a daily basis. That is done. We do call it periodic checks, and it has to go through our dispatch system. So we're holding them accountable. We're getting them into these neighborhoods. A lot of times they're running from call to call to call. But when they do have time to patrol, and I even do it, I deter my routes to go through these neighborhoods and just to be safe. And that's what we encourage our officers to do. So we're trying to address that, yes.
Chief Kim? And Chief, if we could also tell them that right now with the BRAVE effort and what we're doing with statistics, we've taken all of the police and sheriff's reports and we're doing them every day. And spatially, they're now telling the police where to go at certain hot times and places, so they will concentrate on those particular areas versus somewhere else.
Thank you, and this concludes our luncheon for today. We'll be back here on the third Thursday of September with another exciting topic. I believe we'll be discussing the financing of our schools, because there are a lot of facts that you don't know about that. And let me close with one thought and to make one request of you. In trying to bring our community more together, stop and think of every human being in our community as an American of African descent, of Irish descent, of German descent, but we're all Americans first and foremost. Amen. I guess it is sort of a prayer on my part.
Yeah, just about the I wasn't able to put my microphone.